Reed. Pam's our office manager. If y'all have not met Pam, and I'm Steve Reed, and I'm the owner of the title company, and I'm also a real estate attorney. Been practicing law here for about 35 years now. It's hard to say that, but it's true. First of all, I just want to really thank you for letting us come and visit with you today, and I want to just assure you that we will be respectful of your time. I know that everyone is busy, and I also just want you to know that our goal is to make sure that when this presentation is over, that you're able to say it was worth my time to take out from the busy day that that I have to listen to this presentation. It's always our goal at StoneWall Title Company to serve you guys. Our motto really is, if our realtors are successful, we're successful. So we're very, very committed to your success, and there's a lot of things that we do day in and day out that you don't see that are responsive to that motto and that goal, but we really want to live that motto in tangible ways. And so if there's ever anything we can do to assist you, then you know where to find us. And so we just want to extend that invitation. I like small groups, and I'm glad we've got a small group here, and so everybody can just be comfortable. I'm going to start with kind of a compulsory joke, and I usually tell lawyer jokes, but this one's going to be a realtor joke. And there was a particular realtor who will be nameless that was a top producer, and they were on vacation down the coast and walking along the beach one morning and happened upon an oil lamp that had washed upon the beach, and being the ever optimist, they picked up the lamp and rubbed it, and sure enough, the genie was there. So the genie offered 3 wishes, but after visiting with the realtor, said that there was a condition for granting the 3 wishes, and that was just based on the realtor's success as a top producer, that there had to be a lesson of humility that went along with granting the 3 wishes. And so the caveat, if the realtor wanted the 3 wishes, was that their fiercest competitor received twice whatever they received in the wish. And so the realtor considered that for a moment, deciding, okay, I can live with those conditions. And so his first wish was for $10 million, and so the genie granted the wish, and the fiercest competitor got $20 million. The second wish was for a vintage Ferrari. So again, the realtor received a vintage Ferrari, the competitor 2 vintage Ferraris. And then after some thoughtful contemplation, and before making the third wish, the realtor said, I wish to donate one of my kidneys. I guess the point of that little joke is just to recognize that, like many industries, the real estate industry is a fiercely competitive industry. And so one of the things that we hope to do today is just to help you guys be more competitive and have another, sharpen, one of the arrows that's in your toolbox in terms of the services that you provide. And so the title of my little presentation is the ABCs of the title commitment. And I'm going to make a statement that I'm sure all of you would agree with, and it may describe you, but every realtor should review the title commitment to every transaction that they are involved in. And so you say, why is that? And some of these are obviously rhetorical questions, and you know the answers, but if you'll bear with me, that commitment is integral to the transaction. The title commitment is really integral to every single transaction that you're going to be involved in if title insurance is in play, and it should be. it contains vital information about the transaction and about the real property that is the subject of the transaction. And there are also key deadlines and earnest money contract that's tied to that commitment. And so I want to take a minute, and I think you have in your material there, you should have the second page of just a typical 1 to 4 family residential contract. You should have page 2. And the last numbered paragraph on page 1 is title policy and survey, and that's what carries over to page 2. And if you work your way down to paragraph D there, I want us to take a look at that provision, because it's what really ties us to the to the title commitment, and it has contractual obligations that are related to that commitment. So if you'll permit me, I'm going to just read that and ask if you guys would read along with me. But it says the buyer may object in writing to defects, exceptions, or encumbrances to title disclosed on the survey other than items 6A 1 through 7 above. The buyer may object in writing to defects, exceptions, and encumbrances disclosed in the commitment other than 6A 1 through 9 above, or which prohibit the following use or activity. And that's, you guys, a lot of times, that blank is not one that you necessarily fill in every day, but there are several examples that I think are everyday transactions. It might be, for example, that if it's a lot that somebody wants to build a 1,500 square foot home, and so you've got to make sure, for example, the restrictions allow for a home of that size. They may want a detached garage. They may want no garage. They may want to be able to have a home business. They may have a pet pig. They may want to build a swimming pool. Well, can they do those things? If you're actually representing a buyer and filling out this transaction, and they've got some specific thing that they want to do with that property that's not already there, then of course this would be a place that you would fill that in. I'm going to go ahead and finish reading a section here. It says the buyer must object the earlier of the closing date or blank days after the buyer receives the commitment, exception documents, and survey. Buyer's failure to object within the time allowed will constitute a waiver of buyer's right to object, except that the requirements in Schedule C of the commitment are not waived. So here you've got a provision that says that the buyer's going to receive a title commitment, and then the buyer, upon review of that title commitment, has a specified period of time within which to object to any of the conditions or exceptions in the title commitment. And if the buyer, fails to do that within the time prescribed, which you guys fill in, then the buyer waives those objections. So if I'm a realtor and I'm representing a prospective home buyer that wants to build a pool, and I send you the restrictive covenant, the title company sends me the commitment, and I don't review it, and one of the standard exceptions in a commitment is the restrictive covenants. If it's in a neighborhood that has restrictive covenants and it says no pools, and I don't catch that, and my buyer doesn't object, then somebody's going to be unhappy when we get to closing, or even worse, post-closing, and it very easily could come back on you as a realtor. And certainly it keeps you from accomplishing your objective of providing the best possible representation to your buyer. And so and I've seen other things here recently. We had a transaction that there was an easement that went right across the middle of this lot, and it really almost made the property unbuildable. Well, that showed up, in the title commitment, but nobody objected to it, and then you've got a potential issue or a potential problem. So there are a number of times, more than more than we can begin to mention or enumerate in the few minutes that we have here today, but that you can have that type of issue come up. And so really it's incumbent upon you as a realtor to review that commitment and make sure that you know if there's anything in there that affects your client. And there's some things that, and I would say it's more important, I think, if you represent a buyer than if you represent a seller. But there are issues, and we'll talk about some of those a little bit later on in the program, that affect the seller side of the transaction as well. Because if you've got a curative problem that comes up in that commitment and the seller has to cure, and there's time constraints within which the seller has to do that, then you want to have the best jump on those issues that you possibly can. And a lot of those issues, I'll just go ahead and say, really have to do with, probably one of the most common scenarios would be how title is vested, if there's an heirship issue or a title issue, and we got to go try to figure out how to get that cured before closing. So in any event, that kind of is one way that the commitment is directly tied to your earnest money contract. So that's obviously one reason that commitment is very important to the transaction and to you as a realtor involved in that transaction, because of those key deadlines that you definitely don't want to overlook. And you certainly don't want to have to be the one that goes back to your client and says, we missed that deadline and we can't object. And we see that happen, not often, but we certainly have seen that happen in our business. And I'll just insert kind of a comment here. I will tell you, part of what we try to do as a title company, our responsibility is to get that commitment out to you and to get it out to you timely, or out to the buyer and seller timely in accordance with the provisions of the contract. But we try not to do that in a vacuum. If we see something that's glaring, we're going to do our best to make sure that you're aware of that. But we're not always privy to what all of the issues are, i.e. somebody wants a swimming pool, or, so we don't necessarily know everything there is to know about what's involved in the transaction from a buyer or seller's point of view. But if we find something that we really see that we know is going to be a problem, we do undertake to make sure we communicate that with you, although it's in black and white in the commitment. So my question, yes sir, Pete.
What do you typically see when they're filling in the blank of the number of days? What do you most object the earlier of, and then what do you typically see? 3, 5, 7?
Well, so that's a pretty good answer. 3, 5, and 7 are probably the most common numbers that I see there. So, the nature of the world that we live in and the nature of the beast today is everybody's inclined to want to put 3 in there. And I would suggest to you as a realtor, when you're negotiating that, you really want to think about it from how much time do I reasonably need to look at the commitment and have a conversation with my client if there is an issue and write an objection letter, because that's what happens next. If there's a problem, in order to preserve your rights under the contract, you've got to send in a letter. If you're a buyer, you've got to send a letter to the seller objecting to whatever it is in the title commitment that's creating a problem, from your point of view. And then that puts the onus on the seller to either cure that objection or, it gives you the ability to terminate the contract if that's what needs to happen. So, but what it does highlight, your question, Pete, is really how important it is, I think, as realtors, you really ought to be looking for that commitment, and the minute it comes in, your first opportunity, you should review the commitment. And so, the question is the title commitment routinely reviewed by the real estate agents in every transaction? And You guys tell me, probably not.
Who's that B, the one that has a lot of problems in it?
B and C,
B and C.
but yes. And so, and we're gonna really drill down on those schedules in just a minute here, but,
We just say in general that 7 is better than 3, because according to the truck contract, if you find out there's a problem on Friday, then by Monday, you would have to have something in place.
yeah.
Okay.
I
So-
always put 5. I don't know.
So, and again, I think it really just depends on, it's almost more of a realtor-driven date than it is a buyer or seller-driven date, because the real question is how much time, because you know that in 99% of your transactions, your client is really relying on you to advise them if there's something that's objectionable and make sure that they get their objection in timely. So it's really how much time do I need? If my routine number, if I were in your shoes, would probably be 7. You know, because I just think that's a pretty short window. And like you pointed out, P3s can be an almost impossible
Correct.
window.
Especially the holiday following the Sunday.
Right. And so if you're just saying, hey, I'm gonna have a standard rule of thumb without having to think about it, you know, too much, then I'd say 7 is a good, you know, is a good number there.
On those objections, you know, you say you need to write in there, so you should look at the deed restrictions and stuff first and see what is not prohibited or prohibited based on what your client, like you said, may want to pull. I mean, you should know those things.
Well, I would say this, I mean, if you know, for example, if Pam comes to you and says, I want you to be my agent, my buyer's agent, I'm looking for a home and I want to build a swimming pool. Well, if you know that going in, then, you know, I would say, if you say to Pam, well, if you take her out to look at houses in Water's Edge, I'll just say, and Water's Edge really doesn't allow pools, or it's very impractical to put one in out there, then that probably isn't the place you ought to be taking her to look at houses, because when she finds one out there that she likes, and then it's like, oh, well, oops, you can't put a pool there, then she's frustrated because why you took her out there, helped her find a house.
Get ahead of it and know it in the beginning.
Absolutely. I mean, I think on any of those things you can get ahead of. You know, sometimes things that, here would be an example where you wouldn't necessarily be able to get ahead of it near as reasonably. So if you had an HOA that just didn't allow pools, well, that's a no-brainer. You shouldn't be going out there, and you should probably know that. But, you know, maybe it's a house that Pam finds and it's set pretty far, it's small lots, it's set pretty far back, and maybe there's a flood easement that's not on every lot out there, or there's a utility easement that on that, it's a corner lot, and for some reason it just happens to encroach, you know, fairly deeply into the back of the property. Maybe it encroaches 25 feet in, and that just doesn't leave enough room for a pool. Well, you wouldn't know that until you probably looked at the restrictions or looked at a survey. So, and that's another class, but I'll just throw that out. I think as important as reviewing the commitment, or almost as important as reviewing the commitment, is to review the survey, because it's going to help visually reveal some of these same issues that, you know, you might not read a set of restrictions and pick up on. But we'll save the survey generally for another day. But again, so, you know, the question really for y'all today is, do I review the commitment in every transaction? And if you don't, it's how do I come up with how do I improve the service I provide by incorporating, that into my routine process. And I think when you say, okay, well, how do I do that? Then I think you have to ask the question, well, why don't I do that? And I think there's some good reasons why we don't probably routinely look at those commitments as often or as soon as we should. And so some of those whys are because it's too cumbersome. I mean, you know, it's 13, 14, 15 pages plus, and it's in legalese, and, you know, it's a lot to work your way through. And then you have a question of, well, when I do look at it, do I really know what I'm looking for? And then, you know, I'm not very familiar with commitments, and so I don't really know how to navigate it. So what I hope to do today is really narrow down to just a few key things. What do I look for, and how do I navigate it? So that instead of it being a cumbersome process, it's really a process that within 15 minutes you can sit down and work your way through a commitment, and at least have checked off the key issues and know, am I good, or do I need to dig deeper? But so the goal is, if we can just make that easy for you guys, then you're going to be more likely to be able to accomplish that and get that done. And so I think everybody has a commitment there with them. So when we ask the process, how do we simplify it? We ask the question, how do we simplify the process? I'm going to say, number one, we can eliminate half of this document. Okay, so if we can just summarily get rid of half of it, well then, you know, it's already 50% less work, right? So on this commitment, if you'll look at it, and down on the bottom left-hand corner, you'll see it's page 1 of 13 on the first page. So if you'll flip through the first 5 pages, there's not anything in those first 5 pages that you routinely need to look at. So when you get the commitment, now every underwriter's commitment format is slightly different. So, you know, this happens to be a First American one because you guys see it a lot. We're not even the only title company in town that uses First American, so I picked them because it's a real common one. But they're all a little different, but not enough to really impact what we're going to say today. So everything before Schedule A, you do not need to routinely look at. So, but just one time, I am going to call to your attention a couple of things in those first 5 pages that you should just be aware of. And the 5th page, the last page in, is just the deletion of arbitration provision. So you always get a copy of that deletion of arbitration form. So what that is, if there's a dispute involving the title company, or the title policy, excuse me, then the standard language in the policy says that the parties will arbitrate that dispute with the title underwriter. If they don't want to arbitrate that dispute, they want to be able to go directly to litigation, then you sign this deletion of arbitration provision. Every closing you go to, you probably, you know, the escrow officer probably mentions that. So that's all it is. The standard language in a title policy says that the parties will arbitrate a dispute, and if you don't want to be bound to arbitration, your customer, the buyer, or whoever the insured is, simply signs this deletion of arbitration provision. So that's one page that's in there. There is the 4th page in is really just all of the contact information in English and Spanish, and it also tells you if somebody has a dispute, you know, it has that contact information. So it's just standard disclosure things. If you go to the 3rd page, down at the bottom, it says conditions and stipulations. And that first one, I think, is important for you and your client to be aware of, because if you have actual knowledge of an issue with the property that affects the title to the property and may affect the transaction, and you do not disclose that, it can adversely impact the coverage that you have. So in other words, you can't just lie behind the log with some knowledge. If you know there's a lien out there, or if you know there's some issue out there that the title company hasn't identified in their commitment, you have a knowledge to tell them. And if subsequently it comes, there's a claim on the title policy and it comes out that you knew about that issue and didn't disclose it, that's a defense that the title company can raise not to pay, or the underwriter can raise to deny the claim.
An example of that would be child support that the title company didn't pick up, or would they always pick that up?
Well, they should pick it up.
Right. But if they didn't and you knew it,
Right.
then that would be their defense.
Right. So I would say, take the time to read those first 5 pages one time, but other than that, you don't really ever have to worry about them unless, you need that information. But,
Can we talk briefly about page 2, mineral and mineral rights?
yes, sir, sure can.
Okay. And so, someone says, I own all the minerals, and I'm willing to transfer those at closing. And so we fill out the mineral addendum. And it turns out that that's not true. How would that be handled?
Well, so there's probably a couple of different ways to answer that question, Pete. I'm going to initially address it from a title company's point of view. So we have a general minerals exception in the commitment. So title companies, as a general rule, do not insure minerals. And so if you have a seller who contracts to sell the minerals, purports to sell the minerals, and does not own the minerals, and that later results in a dispute, there's not going to be title insurance coverage to address that. So that's kind of the title side of the question. Just in general, you have a seller that's selling property, and if they're purporting to sell all of the minerals, then it should definitely be something that is addressed, I think, in the contract, in special provisions, where it is very clear that acquiring the minerals is a term and condition of the transaction. There's normally a standard exception or reservation for any and all minerals that have been previously conveyed. And so that warranty deed is going to have that kind of standard language in it, unless the drafter of that deed knows that, hey, the seller is warranting not only title to the surface, but title to 100% of the minerals.
Okay, so in the part provisions, you would make that a part of the agreement?
Yes.
You call it out.
Right.
Well, real quick, my understanding too is, and you won't tell me, if the seller doesn't serve minerals, there's nothing in the contract about that, and it goes to closing, and nothing's ever said, that the minerals automatically transfer to the new buyer.
Yes. So one way to think about it, and to maybe help understand that issue, is that the minerals, they're part of the real estate. And so in Texas, you can actually sever the mineral estate from the real estate. But if they haven't been severed, anytime somebody purports to sell a piece of real property, lot 1, block 2, in the Harbor Lakes edition of phase 22, whatever it is, if there's no reservation of minerals in the contract for sale, the earnest money contract, then the presumption is that everything that is being sold. Now, to look at that from a different point of view, you can always only sell what you own. So if you purport to sell the minerals, but you don't own the minerals, you haven't sold the minerals. you know, you have the typical form of document we use to transfer title is what we call a warranty deed. And so that term, the deed, it means it's a document that's actually transferring ownership. The term warranty there is descriptive of the fact that the seller is providing some kind of warranty with regard to the transfer of that title. And so there's special warranty deeds, there's general warranty deeds. You always want to look at that language if that's an issue. But really, it's a great lead into, and I don't want to chase this rabbit too long, but I'll just make a quick comment. That's really what title insurance is about generally, not so much about minerals. But if I'm a seller and I warrant title and I file bankruptcy next week after the transaction closes, and there's a problem with title, you can't come back to me. Maybe I died, you know, maybe I don't have heirs, or, you know, or there's lots of reasons why that warranty is not a tremendous amount of comfort to a particular buyer, depending on the transaction. Now, it may well be, and certainly there's lots of lawsuits that get filed based on the fact that somebody warranted title and didn't transfer good title. But the idea behind title insurance is that the title underwriter is going to be there, or the seller may not be there, or the seller may have had that obligation discharged, or the seller just may not have any money. And so, it's always going to take a lawsuit, probably or most likely take a lawsuit with the seller. Title companies are geared to pay claims. So, those are just some things in general to think about. But as it relates, to the minerals, generally speaking, we don't insure minerals, and generally speaking, if you have a buyer that acquiring minerals is a part of the transaction, be sure that you put the mineral addendum on there and you make it clear in that mineral addendum what the percentage of minerals are actually being contracted to be conveyed.
What if the seller says, I don't think I own the minerals? Just put their unknown or?
Well, I don't think you should ever purport to convey,
like in case the lease and all the different things.
then you should just
one line?
You should just not sell minerals. You should just one thing you can do is just put surface estate owned. That's,
Okay.
in Pecan, you see that all the time, because that's the way the developer sold all of those lots. In the legal description, instead of just saying lot 1, block 2, it says surface estate only, lot 1, block 2. So that's a simple way. If your guy doesn't own the minerals and he wants to make it, or he doesn't know if he owns the minerals.
And she doesn't care.
Yeah. Well, so if you don't care, if you say surface estate only, you're only going to convey surface estate. So if you just, you could just say in special provisions, buyer makes no representation regarding minerals. Buyer may or may not own any minerals and is only conveying the minerals that the borrower owns, if any.
Yeah.
Or the seller.
Seller owns it anyhow. Good. Yep.
Because, that's a.
She's owned it for 19 years. And she goes, I don't think I own any.
Well, I would just say the most common scenario in Texas today is that all or a portion of the minerals have been severed from almost everybody.
That's what happened.
It's not always the case, but the vast majority of times it's going to be.
Especially if you get into subdivision, platted subdivision.
Right.
Yes, sir.
Especially.
We've actually had some platted subdivisions in Hood County where a developer did not reserve the minerals, but they that was a misstep. That should just be the routine part of the process. Okay, so now we're really going to look at the ABCs of the process. And so you can kind of look up on our screen in your notes. After you get past those introductory pages, there are 4 schedules. And I don't care whose commitment, if it's a Texas commitment, you're going to have schedules A, B, C, and D. All right? So again,
You should have this paper also to follow along.
yeah, and you got, yeah, and so what I'm really interested in, Schedule A is facts about the transaction. Schedule B is restrictions and other notifications regarding the condition of the property that the buyer needs to be aware of, and exceptions, things that we're not gonna cover, okay, the title company's not gonna cover, title underwriter. Schedule C are things that have to be cleared in order to close. Just the simple example would be if there's a mortgage, there's an outstanding, if I'm selling a house and I still, I borrowed $200,000 to buy it and I still owe $100,000, that mortgage lien is out there. Well, when Pete buys it, he doesn't want it to be subject to my existing lien. So that lien has to be paid off, has to be cleared to close. So we like to say Schedule C is clear to close. And then Schedule D is disclosure. And so, really, Schedule D, you don't ever need to look at. I mean, unless you just want to know who owns the title company or who owns the underwriter. And so,
That's y'all's disclosure.
right, so if you looked at one of my commitments, you would see that StoneWall Title Company is owned by a company called A Block Inc., which is my corporation, and then me personally. In our case, it's a limited partnership, StoneWall Title Company is, and until about a year ago, I had a partner, Roy Sparkman, but I bought Roy out, and I think he's still listed because we have to list him for a while longer, just based on the way the rules work. But I'm really the sole owner of the title company, but I own it as a general partner and individually. But if you look on Schedule D, that disclosure is there. Early on when we were a title company, there was a lot of speculation and a lot of rumors about who owned our company. And I would tell people all the time, it's Steve Reed and Roy Sparkman. But, don't take my word for it, just go look at Schedule D. The Texas Department of Insurance requires that we disclose that, and they monitor that every year. So if you ever have a question on any title company that you're dealing with, who the owners are, it's right there in black and white. But again, in terms of looking at routine transactions and trying to represent your client, that's pretty irrelevant, right? We want to drill down on the stuff that matters. So let's start with Schedule A. All right, so you're gonna see there's a little ledger there, and we have, what's highlighted in yellow is non-promulgated text. What's highlighted in green is for lender policies only, and what's highlighted in blue is for owner's policies only. So in the typical transaction, you either have owner's insurance, the buyer's getting an insurance policy, and or you have lender's insurance. The mortgage company's getting an insurance policy. And as you probably know, there's no requirement under the law when you sell a piece of property for the buyer to have title insurance. Now, lenders are required as part of their process to have insurance. So if it's a non-cash transaction and you've got a traditional lender involved, you're going to see a title policy, what we call a mortgagee's title policy. And if you look at your commitment under paragraph 1, you're going to see what type of policy it is. So here's a Texas residential owner's policy, what we call a T1, and you're going to see the dollar amount, so that you want to look and say, is that dollar amount right? Is that that's the purchase price right there, $40,000. And proposed insured, the name of your buyer is going to be right there. And then in the next paragraph, C, you're going to see that you've got a lender's policy, a Form T2. And so you're going to have a policy amount. In this case, it's $32,000. It's nearly always going to be less, and it's rarely ever going to be more. Sometimes it is more if they're doing a loan for some improvements.
So the difference between those two numbers would typically be the down payment?
Yeah, typically be the down payment. And then you'll see even under the lender's policy down here, it has the proposed borrower. So the proposed borrower is nearly always going to be the same as whoever the buyer is. So that's where you make sure that the information about the policy is correct as far as the owner, and the amount of insurance. And you can't say, okay, I'm buying $1 million house, but I only want $500,000 worth of insurance. The insurance amount has to be the same as whatever the sales price is,
Even if you're paying cash,
even if you're paying cash,
if you want a policy.
if you want a policy.
Okay.
And that's a requirement of TDI. Then, when you come down to paragraph 2 here, it just tells you how the land is owned. So what you're really looking for and what you're gonna see 99% of the time is fee simple. Somebody has fee simple title. If it's something other than that, you probably wanna call your title company and say, hey, what's up here, and is there anything we need to address with that? But, and then paragraph 3 is house title vesting. Okay, so the owner of this property is owned. And then number 4 is the legal description. So you want to make sure if you're representing the seller, and you know, if I'm the seller and Pete's representing me, and it says titles vested in Robbie Reed, Pete's like, hey Steve, you're the one that signed this contract, man. I thought you were the seller. So why is Robbie listed as, you know, as the owner? I mean, it's a flag to you guys to say, I need to ask some questions of my client and figure out, you know, make sure that whoever owns the property is going to be a party to this transaction and be able to sell. And I could say, well, Robbie and I got a divorce and the property was awarded to me, and that divorce decree hadn't been finalized yet. Or, you know, that's the reason it's showing up in her name and not in her. There can be some logical, you know, answers, but you know, sometimes, you know, you might say Robbie Reed might be the seller, and the title might come back Robbie Reed and Sam Reed, Benjamin Reed, Andrew Reed, and Alexander Reed, my children. And they're like, well, I thought Robbie was selling property. Well, Steve died without a will, and those were children from a prior marriage. And so they actually own an ownership interest. And Robbie's like, well, I thought Steve left everything to me. I didn't know his kids from a prior marriage got it. And then we have that come up a lot. So you know, you can, you need to just look, and if you see something there, it's a clue to you that, hey, I may have some work to do before we get to closing.
So if you see a name there that's not on the contract, we got a flag.
Right, you got a flag just because you're trying to sell for somebody that doesn't have to give you a commission, you know, or may not want to sell, or that you haven't contracted with. So, you know, so those are the issues on Schedule A.
The next one is the estate.
And so, you know, again, I would just say, really, as you can see, looking at Schedule A is really quick, really down and dirty. You just want to check those, you know, really those 3 boxes or 4 boxes, and just make sure that you know, what you see there is consistent with what you understand the transaction to be. You know, here's another thing you can see under record title, just as an example. This says Daffy Goose, independent executor of the state of Daffy Goose the second, Daffy Goose the third. So again, if something is in probate, well then you may have had an heir come to you and say, I'm the beneficiary, you know, I want to sell the property, and then it turns out, well, there's actually an executor, and that executor has the authority to transfer, and until the probate's completed and the executor deeds that property out, you know, the ultimate beneficiary may not have authority to sell. And so there's various other issues. And another issue that comes up with us sometimes is you've got a really quick sale after a death, and somebody may say, well, I don't want to probate a will because that's too expensive. And you know, sometimes as lawyers, we don't always recommend probate of the will. There's, you know, sometimes an affidavit of heirship can be just as effective, and it's not as expensive depending on what the facts are. But if you just assumed you had a situation where the facts warranted affidavit of heirship, is fine. But title underwriters won't let us close a transaction, depending on the underwriter, for 6 months to a year after somebody's death based on an affidavit of heirship. It has to actually have been probated. Now, probate's quick and easy in Texas. We can do it in 45 days or less. But
it's not cheap.
it's not super expensive, but it's not as cheap as an affidavit of heirship for sure. But if you want to sell it right now and it hasn't been 6 months, well then you're gonna have to probate that estate. And so, again, it's just important to look there and make sure you see how title vesting.
Where is that on here? I didn't see it.
This was just a different Schedule A, just as an example.
Oh, okay.
So again, so you can see at the very top, this is a Schedule A,
Right.
and so it's just a little simpler Schedule A.
Okay.
Okay, so any questions about Schedule A? Again, you know, if the title company sent you a commitment today, and you threw away the first 5 pages and you got the Schedule A, you know, that's 3 minutes to look at that page and see those, you know, see that information that you need to know. Okay, so Schedule B. The one thing that I want you to realize about a title commitment is a title commitment is a promulgated form by the Texas Department of Insurance. So you can't just change it. There's a lot of language in there that's mandatory. And so even though it may not apply to your transaction, we can't take it out. There's some things I really wish we could take out because it just makes understanding the commitment easier. So I'm going to give you an example of that. If you look at, well, let's just start up here at the top. This is exceptions from coverage, okay? So this is a title company telling you that we're not covering these things, okay? So when you get a title insurance policy, it's not going to cover these things. And so if there's shortages in area or boundary lines, or there's encroachments or protrusions. So if you have no survey and you have a house and the neighbor's house protrudes onto the lot that you're selling, or this house protrudes across the line onto the neighbor's lot, we don't cover that. Now, if you get a survey and you get survey coverage, we review the survey. If the survey shows that there's no protrusion, then we'll insure that. But if you bring us a survey that shows the protrusion, then we're going to accept to the protrusion, which just makes sense. Obviously, we're not going to give you a policy where you can come back next week and say, oh, my house is on the lot next door, now I want you to pay to move it. So, so these are things we don't cover. And so if you come down to paragraph 4, okay, these are things that have to be in a commitment. Tidelands or lands comprising shores or beds of navigable rivers, streams, lakes, bays, artificial islands, filled in lands. So there's some things on here that really relate to the coast that don't even apply. There's some things that relate to navigable rivers that would only apply if you had property that was, you know, on the adjacent to the Brazos River. But those are in there whether they apply or not, just so you know. The number one thing that you're always going to be looking at when you get to Schedule B is number 1 here. And that's where we list the restrictive covenants. So you can see this is a big one here, but if you've got, you know, this would be Pecan or De Cordova or Mintwater or someplace that's done a lot of amendments to their restrictions and covenants over the years. Every time they've updated them or amended them, all of those different documents are referenced here. And so, so if you're in a subdivision, then that's where you're going to get a list of the restrictive covenants. Now, the other thing that happens from time to time, and Pete, you're probably as familiar with this as anybody, but you know, you may have a piece of property that's out in the country, and you know, somebody that, and maybe it was at one time a fairly large acre tract, and maybe they decided to sell part of that off, and they got thinking about it, said, yeah, I'm going to sell off, you know, 10, 20 acre tracts. I'm going to sell off 200 acres from my 1,000 acres, but I sure don't want a pig farm there, or I don't want somebody putting a double wide on it, or anything that particular seller didn't want. Well, when they sold those lots, in the deed, they would just put a restriction that said no double wides, or no mobile homes, or no pig farms, and so those things will show up here too. We'll reference the deed where that restriction is. So if Pete sold it to me and, you know, he carved out, you know, 20 acres off of his home place and sold it to me, and he said in the restriction, Steve, you can't have a manufactured home on that property, and that's a restriction, then I get ready, you know, to turn around and sell it to Star, and Star's plan is to put a mobile home on there. Well, you're gonna see that reference up here to the deed. Now, in this paragraph right here, it's not gonna say no mobile homes. It's just gonna say that there's a deed recorded in volume and page, volume blank, page blank of the real records of Hood County that has restrictions in it. So then you wanna say, well, what are those restrictions? Or, you know, we make a copy of all these documents here available to you, and so, you know, you can call us and ask us about them, or you can review them, but restrictions is a big deal to always look at. The discrepancies, conflict, shortages in area and boundary lines is always something that can be addressed with the survey. Homestead and community property and survivorship rights is something that we don't provide that coverage to in an owner's policy. So it says owner's policy only. This one says owner's property only. So those are just, you know, you're gonna see again these in every file, every commitment. So 2, 3, and 4, and 5 are standard exceptions. 5 has to do with taxes, with ad valorem taxes. So we do not insure against future ad valorem taxes. So you would see, flip back to that page, that we don't cover the current year or any future year. And so, so you'll always see that in that exception number 5. Go ahead.
So you don't cover the current year or any future years because you will collect any taxes delinquent at the time of closing.
At the time of closing. Or the parties will make some kind of an agreement and arrangement that's executed at or before closing. Number 6 is terms and conditions on the documents creating interest in your land. Obviously, if you're borrowing $200,000 and signing a deed of trust at closing, we're not going to insure the property as if that lien didn't exist. So it's always going to be subject to that. And then if it's construction, you have this provision that has to do with the materials that are being provided during construction. If there's liens or leases that affect title to the land but are subordinate to the mortgage lien, for a lender's policy only, we don't cover that. Again, these standard printed exceptions really aren't something that I think you guys are interested in. And then, so the real paragraphs, if you said to me, Steve, what are the most important paragraphs on Schedule B? Paragraph 1, which is where you have your restrictions, and paragraph 10. And paragraph 10 is non-promulgated text, and that's going to show you all the things that we found out there when we researched the title. So number 1 is standard promulgated text, rights of parties in possession. So if you're buying a house and maybe there's a tenant in it, we're not going to insure whether or not that tenant has any rights. And what we normally do is we ask you to waive that rights of parties in possession coverage. And if you say, no, I don't want to waive that, I want you to go out, I want to pay you as a title company to go out and inspect the property and make sure there's no one in there. We do that from time to time. It's very uncommon. A typical situation would be, you know, maybe if somebody was buying 1,000 acres of ranch land and they wanted somebody to go out and actually do an inspection and make sure there weren't any, any squatters on that land. I really see it mostly in commercial transactions where, somebody's buying a large piece of commercial property. I actually had one that we had to do off the Trinity River, and it was an overgrown creek piece of property right by the Trinity River in Grand Prairie in the industrial area, and it was right off the highway, and there was a lot of homeless people that were actually living on that property. So we had to go out, we inspected the property, we saw that, we had to identify that as something that we were, covering. You then have, after the rights of parties in possession, you have all of the easements and the utility setback lines. So you got your building setback lines, your utility setback lines, front and rear property setback lines, any easements that affect the property. So you see all of those are always, any oil and gas leases, all of that's gonna show up on here. You won't always see the leases anymore. Some title companies, as opposed to listing those, they just have a standard exception to minerals, and so they don't provide any coverage regarding minerals. But you're gonna see these are interests in those minerals. So these wouldn't have to be on there. But you wanna really look at just at this paragraph 10, and it's gonna have as many, I think probably, I've had one commercial transaction where we went through the alphabet 6 times on this. So we had paragraph B, because there were just that many, there were 260 exceptions on there. So, but normally you're not gonna see near that many in your transactions. I'm glad to answer any questions, but restrictions, taxes, easements, mineral reservations and leases, area and surveys, discrepancies and rights of third parties. I might have an access easement across your property to get to mine if I had an otherwise landlocked piece of property that's set behind yours. So those are all things. They're much more relevant when you're not in a residential subdivision, because when you're in a subdivision, most of those things are all addressed in the restrictions. But there are always things to look at on the SB. And then Schedule C, again, that's the clear to close. So that's where you're gonna find liens. If there's, and so one thing we find from time to time is there's an old lien on a property that just didn't get released. So security matters, you gotta go back and find, the bank got paid off. They just, either they didn't do a release or they did a release and gave it to the borrower and the borrower didn't record it. So you've got a lien out there. Maybe there was a judgment lien or an IRS lien, maybe I'm selling a piece of property and 10 years ago I got into a dispute with somebody that I was doing business with and they sued me, and somehow I didn't realize that in JP court, and there's some little JP judgment against me that I didn't even know existed. It can happen. It's not likely, but it can happen. And so you're gonna see those judgment liens or IRS liens or any kind of liens out there. If somebody has filed bankruptcy, we'll see that, and that can be relevant to the transaction because it may be that debt's been discharged or there may be a claim of a trustee. So we need to know that. If there's been a divorce or if there's a marital status issue. A real common thing is, again, a title might be vested in Steve Reed. And I might go, enlist Pete to sell a piece of property for me, and we look on Schedule A and it'll say title is vested in Steve Reed. But as a title company, when we research the title, they're gonna say, well, Steve Reed's married and his wife is Robbie and we're a community property state. So they're gonna say in Schedule C that if Steve determined the marital status of Steve Reed, and if he's married, a requirement of the title company is that his spouse join in the conveyance. So, you'll see that. If title is held in a trust, then there may be a requirement here. We'll have to see the trust instrument in order to verify who actually has authority to execute the deed on behalf of the trust. or if title is held in Pete James LLC, or Tommy Carpenter LLC, or, then, we don't just assume, and we can't just assume as a title company that Tommy has the ability to sign on that LLC. Depends on what the operating agreement says. And so if the seller is an entity, you're always gonna see exceptions on here because, and really a way you guys can help your clients and help the title company a lot when it comes to dealing with entities. People, for some reason, are very guarded about their entity documents, but we really have to review those to know who's gonna sign. And if Tommy, if you come sign me up and I'm saying, hey, it's my company, A Block Inc., you should just go ahead and say, Steve, I'm gonna need a copy of your corporate documents because the title company's gonna have to have those in order to verify your authority to sign, or who has authority to sign. So really, one thing that will help us expedite the process and help, which helps, everybody, including you guys, is anytime you're dealing with an entity of any type, we're gonna have to see those, those documents. And you're always gonna see it. If you don't realize that even, maybe I don't tell Tommy that I'm an LLC, but when the commitment comes out and it says the title is vested in A Block Inc., then Tommy knows when he looks at that commitment, he's gonna pick up the phone and say, hey, Steve, is it right you own this property in your corporation? And I'm like, yeah. And you're gonna say, well, then Tommy can say, oh, well, we're gonna need to get those documents to the title company because they're gonna have to have those as part of the transaction. So it really helps you be on top of your game and helps you help us move that transaction forward as quickly as possible. And when I told my little joke at the beginning of this program, one of our goals is to help you guys be as successful as you can be. And I haven't really thought about what would be the best way to maybe integrate into your own personal marketing your understanding or your review of the title commitment. But I think we live in a day and age, the title world is ever evolving, and so is the real estate industry. And used to, people couldn't look at real estate except by going to a realtor because it was all locked down in MLS. And now people can see it in a lot of different ways. And so whereas a realtor was an entry into MLS, you guys were kind of the gateway to MLS. So everybody needed a realtor just to have access to property. They don't need that anymore. So how do you distinguish yourself as a realtor? How do you market yourself? How do you present yourself? Still, the vast majority of people that buy and sell property, they don't know all of this stuff that we're talking about, and they need to, because it's probably one of the biggest transactions they're going to enter into, in the course of their lifetime. And so for you to be up to speed and be able to represent yourself and help them understand how you're going to help them navigate all of the waters associated with buying and selling real property, I think is a central key and factor in terms of your marketing success as a realtor. So I think hopefully the better you understand the commitment, then the better you can represent your client, the more successful that you can and will be. And just know for sure our commitment to you guys is to help you any and every time that we possibly can. And that means anytime you've got a question about a commitment, you're welcome to call us. Kim Klein and our abstracting staff are very knowledgeable. Denise Weaver and Stephanie are very knowledgeable escrow officers. We have a very knowledgeable staff, but then over and above that, I'm there every day. And you guys may not have met Sam, my son, who's an attorney that practices there with us as well, but he's there. And so our goal is to make sure we've got plenty of people to address your need when you have a question. you know, as efficiently and as quickly as you need that response. And not only do we want you to be aware of that, but we really want you to rely on that service, you know, that we provide. You know, and I tell people all the time, you know, I do understand that at times you're gonna have transactions that are closing at some unnamed title company that's not StoneWall, and you can still call us anytime. It does not have to be a transaction that involves us. If you've got a question, we're your neighbors, we're part of this community, and we're committed to, you know, to helping you get answers to your questions. But we would love your business, and, you know, of course, we're here because we want, you know, we want your business. We want to be a part of your team, and we want to partner with you to help you be as successful as you can in the real estate market. So for me personally, I want to thank you for your time. I know we've got some sandwiches, and then I think Pam's got some additional presentation. But you know, if you have questions now while we're getting something to eat, I'm glad to field those, or if one comes up, just let me know.
In your folders, there's parts of my part, and right behind it is Steve's part as well.
Thank you.
Yeah, perfect.
Standard for an exception as to description of conflict short.
Oh, yeah, that's sweet.
Yes, I did.
Y'all are gonna get to see a brand new version of this presentation.
Oh, yeah.
Updated yesterday.
So yeah, you might want him to video it.
Yeah, he is. He's gonna do both.
And I'll do, and also, the biggest part of this for you to know is that I do this class custom for
But if it passes
teams.
per capita,
So if you have a team,
the 4
especially with
areas are all
assistants and
gonna
stuff,
record.
that
So
it
yeah.
would be more beneficial to have to sit one-on-one with them
Yeah.
But
and actually set up their
They
system like
won't.
it should be.
my
Pete right now is my only phone.
is there no timeline?
Okay.
Sure there is. So,
Yeah, no, Star knows me, I'm not trained. When I teach, I
So
tell
the
them this is
ant
informal,
had a
I'm gonna
will.
walk, I'm gonna talk, I like to go. Shoot, I'm
I've been,
You never
my
know.
hands
One
been
of
slapped too
the-
many times by IT people.
someone was appointed as an executor of the
I have
estate,
trained with.
and that
Lauren
executor
for
has never
quite a
deeded the
while.
property out of the
4
estate.
years. I mean,
Correct.
I don't know, how long has it been, Lauren?
So normally,
I've been doing the 6, so at least 6.
that
Maybe
executor,
6, it might be 6.
number one, that executor has a fiduciary duty to all
We go way
of the
back.
Yeah.
And, the executor usually has discretion
It's just one of those things.
depending on what the
Because,
will
well, and the
says.
class I used to teach was a
To-
6.5 to 7 hour class. So I told them, I said, we're gonna be in here a while.
I love
We're just
classes
gonna be
like that.
friendly."
I used to train
Sell the
the
property.
same group of people through a whole week.
I didn't realize, because it
Rent,
came so natural to
which
me.
would go to the
I did not think
beneficiaries,
twice
or
about it.
That,
they
Being
have
Yeah,
to
an
be.
issue
yeah.
for other people.
You know,
Yeah,
if
I was the
it's a
same way for a
going
long time
concern.
until
I'll take you right back up.
make her feel really awkward.
Well,
Just kidding.
oh, well.
Just kidding.
We had time frame, she knew it, we're going.
All right. Well, I'm gonna make
I
this
get mean occasionally.
really quick for you guys. First of all, are y'all both? Have you ever been on Qualia Connect? Have we ever seen it? Pete's got it. Good.
I've seen it, but I didn't get on it.
That's okay. That's what today's for. You're good. I have some handouts in your folders. There's 2 of them there. One of them's front and back, the other is not. To follow up on this, everything that I say is pretty much on those handouts. So if you need to circle back on it, don't hesitate to do that, or to reach out to me as well. So Connect, of course, you know Steve. My name's Pam Reed, Director of Support and Strategy right now at StoneWall Title. And then our team, we've had a lot of changes, a lot of great changes. We really see ourselves as the best that we've ever been right now at StoneWall. Stephanie Derrick, Denise Weaver, Shauna Wood on our escrow team. And then on our support team, we have Susie, Amy, Star, of course, and Robbie. And then on our abstract team, we have the Kims, is what we call them, Kim Oakley,
The
Kim
Kim.
Klein. That's the Kim office. So Qualia Connect, what does it do for you? It does a lot for your clients, and we're gonna get into that, but what does it do for you? 6 main points that we're gonna hit on today. Real-time updates. This is something that's a huge pain point within the industry is, where is my file? What's happening with my file? Have you even looked at my file today? Where is it in the process? You know, we equate this to the pizza tracker idea. You know exactly what topping is being put on your pizza these days at exactly the moment and who is putting the pizza topping on your pizza. But for a huge transaction, sometimes the largest transaction in someone's life, you have no idea what's happening. That's the thinking behind this whole real-time updates portion. Strengthening relationships. That's not necessarily our relationship with you, even though it definitely does that. This is talking about your relationship with your clients. It helps their communication with you. It also privies them to a lot of information that they might call or text or email you for, that kind of cuts down on those unnecessary communication pain points maybe when you're getting flooded with conversations. Communicate securely. A huge part of our industry, both in the real estate and the title industry right now, is security. Qualia is proud to say that their Connect system is the most secure title system out there today. It has been certified in a bunch of different ways. I'm not techie enough to spill all those out, nor would they mean anything to you, but they're there. So very secure there. Comprehensive reporting. If you have several contracts at our office, you want to see exactly where all of those are. Maybe you have a team meeting or something like that, that you want to get a comprehensive report on the status of those files. It's a one-click button. You can see all of your files as well as closed files and know exactly where they are in the process. One-click ordering, we're going to get into that. That kind of goes along with Access Anywhere. We know that your job is not always in this building. It's a lot of times remotely. You're working from your car, from your home, on your phone, on your iPad, whatever device you may have, and this is really optimized for that type of business. And the one-click ordering goes straight into that. So if you have any questions, please just jump right in. I'm happy to stop and ask them. So real-time updates. This is the pizza tracker as we last referred to it here. This is our closing tracker. It tells you when your order is in the key parts of our business. So when it gets opened, when it gets sent to title, when we get the title back, so the examination is finished and it's in closing prep, which is pretty much everything before the closing. When we have a closing date, we'll have a star there saying, hey, this is the goal date, this is what we're working towards. And then after, we always kind of harp on closing, but there's so much that we do. Obviously, the most important things that we do happen after closing. We issue the policy, right? That's the reason why you're closing with us here. So we can see when policy gets issued and when the file is totally closed out on our end. So this is your view here. Now I'm going to say all of this to say if you don't have a Qualia Connect account with us yet, it's very easy to set up. I can just take your email, set you up, and you'll be able to see this type of view. If we don't do that today, whenever you submit an order with StoneWall Title, you will get an email notification asking you to sign up. So same process, just before or after. Either way, you're going to get this type of view here. You'll see the order at the very top, and then a bunch of different tabs here, but this will be your home page. If you scroll down after this, it's kind of covered up in blue right now. It has every party on the transaction, their name, email, phone number, and then of course all the order details that were from the contract that we pulled out and put into our system. So it's very summarized, it's very quick to look at, and that's the purpose of it. It's supposed to be easy to look at. You pull out your phone, check it, put it away, because it shouldn't take that much time to get information from us. And this is a key part of it. One point I wanted to say, the last sentence on here says customize how you want notifications. This is a big deal. We know that we're not the only ones that have a portal. It feels like everyone that you partner with today has their own portal. We know that that is cumbersome, but it's the reality of today's industry. But one thing that is really important is that with Qualia Connect, you can choose to get no emails ever, never. You can choose to get a text message for every single thing that happens. So the level of notification is so customizable on certain aspects of the order. Does that make sense? Is that a good summary of that? So, and I can definitely show you how to do that one-on-one to customize the notifications, because my email box was flooded. I know yours are more flooded than mine are. The last thing we want is to add to that strain every day. So strengthening relationships, how does Connect achieve that? Whenever we set up the order, I told you you're gonna get an email welcoming you, thanking you for setting up the order with Qualia, or excuse me, with StoneWall through Qualia. Your buyers and sellers will also get this. So it's important whenever you submit a contract to give us an email address, because this is going to be the essential part of connecting them with Qualia Connect. This is the email that you would get. It says, Michael from, it would say StoneWall Title Company, has invited you to view updates for the purchase of blah, 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 or it would say refinance or whatever type of transaction it was. And it shows them what it is, what Qualia does, and then is a very clear link for them to click and to add in, this is my password. It already has their email filled in. Their personal information is already there. What's really great, I mean, I can ask you guys, how many times have you gotten calls from title companies saying, hey, what's the social security number? How do I get a hold of your buyer? Does your buyer have a mortgage on this? Just so much information that's required for us to do our jobs well that flows through you guys. Happens a lot, right? Our favorite part about Qualia Connect is that it automates all of that for us. There's no more phone calls, no more back and forth trying to get the information before the closing. It actually will automatically send out requests to the buyers and sellers, and you'll actually get some as well to fill out for us, asking them all of their personal information, asking them key questions that we might not even think about at the beginning of the closing, like, hey, are you going out of town anytime before you close? Are you even going to be in town when we close? Are you currently going through a divorce? Have you ever been divorced? Key things that make a very big difference on our side to ensure that the closing happens on time. When we first did this, not gonna lie, we were really skeptical on whether people would actually fill these things out. A lot of people have hesitancies these days about putting personal information in through the internet, rightfully so, but we were so shocked to find that probably 98% of these requests that we send out get fully filled out within probably 5 hours of us
I'm
sending them out.
gonna qualify that, Pam. They get fully filled out by the buyer and the seller.
Yeah.
Exactly, yes,
Realtors
thank
is a
you.
completely different story.
Yeah.
Well, what are you talking about?
But it is amazing. We
Yeah.
really have been surprised by the cooperation and just the participation that we get by the buyers and sellers. But it does really, hopefully, provide a real benefit in the sense that it doesn't, it saves you time.
Yeah,
Well, it saves
absolutely.
the agent time, because
Yeah.
then they don't have to remember to ask their client, are you going
Absolutely.
through divorce? Is there a death? Is there a will?
Yes,
Is
and
there,
our realtors that are using this consistently with us,
they're loving it.
they love it so much. They love that aspect. Just, it's amazing the feedback we get from it. And I'm not talking about like the 25 to 35 age range giving us response.
Yeah.
I'm talking like everyone. Even the
Even the old guys.
Okay, sure.
You see
You
how
said it, not
she-
me.
you see how she's trying to avoid that.
More mature.
There we go, the more mature crowd.
I like to
They're
call it
more,
vintage.
they respond even quicker than some of the younger generation, which is surprising and wonderful. We love it so much. So that's my thing about relationships. It's very professional, it's very easy to use. Qualia in its essence, even on our title side, but especially on the Connect side, is very intuitive. I always say it's like picking up an iPhone. You just understand how to use it. It's just very easy to use. And so that's a key part of this. The way it makes you look to your clients is important to us. And we want to make sure you look like you're in the 21st century. Communicating securely, we talked about the importance of this. A great thing about today's world is that we have multiple people working on your file at one time. When your file comes to our office, 3/4 of the employees that are in our office have worked and touched on your file. That's a lot of people, a lot of communication, a lot of interaction, as well as multiple buyers and sellers. We talked about, if you have a mom and 3 kids, that's a lot of people communicating and interacting. The great thing about this inbox tab is that it consolidates and keeps every conversation thread in here. Now what's awesome is that this is also connected to our Outlook device. So if I comment and Star comments and Denise comments, it's all on one thread. So think of it as like a group text message. Same idea, it's all on one thread here, it's seamless, it will always be here. Every order that you have with StoneWall, even past closing, will always stay in your Connect account, so you can reference any conversation. There's no more swooping emails to your file or anything like that. You have security to know that every conversation, every document that's attached, everything that we send you is going to be in this portal, as well as for the buyers and sellers. So if they need to go back and look for their survey post-closing, it's going to be here. If they want to think about, hey, what did she say that I needed to bring to closing? It's going to be here. Your answer is, it's here. So it really consolidates that. Very, very secure system, very intuitive. And this right here that says requires response, it'll give you reminders and give the borrowers and sellers reminders. If you need something that has to have an answer, it will continually remind them until they answer that question.
What's not there, Pam,
Please.
is the email that you send directly to the escrow officer or.
Exactly.
So if you want it preserved, you have to work inside Qualia. If you send an email outside of Qualia, then of course it's not going to be captured by Qualia.
Right. And this has an incredible alert capability on our side of things. Our entire team gets alerted anytime a message comes in. So the ability to respond to those messages is not reliant upon when Denise looks at her email. We have a whole team around that. So we make sure that it's even more effective communication between us and you, or us and the clients. So great things there. Comprehensive reporting. Just briefly, this is what it could look like for you with all of the orders that you have with us. When it was accepted, when it was opened, when we had a commitment out, a CPL out, borrower information, if you just need to print that for your records or for your broker's records, very easy to do. Obviously it has different dates you can sort it through, and it's wonderful. Just kind of summarizes everything for you, makes your job easier.
And that's when you're happy and we're happy, is when you've got 6 or 8 of those.
Yeah. This is the
Showing up
goal.
at our office.
And you
That's
don't
right,
know
that's
which
right.
one is which.
That's right, you gotta make reports, that's our favorite. One-click ordering. I'm gonna come back to this, but simply to say, if you can fill out half of this information, it will automatically dump into our title software. It cuts your order processing time in more than half. So your order gets ahead of other files that come in that day. Let's say like Monday morning, I always have a huge stack ready to be put in from the weekends, all of the weekend transactions. If it's in Qualia, it's the first thing to come in. So you're ahead of 10 other transactions in terms of the pipeline of who goes first. So it expedites that, makes it really easy. I check everything that's in here to make sure it's correct with the contract that's up there, so you don't have to be worried about that. It gets thoroughly checked over. But it's just something simple to do. I'm going to show you how, let's say your customer asks for an estimate. You put that information into your estimating tool. Through Qualia, that information carries over and says, hey, do you want to order this? And it'll save it so that 2 weeks, hopefully it's not 2 weeks, hopefully it's 2 days after that estimate, they go, yeah, let's do that. All you have to do is push a button. You don't have to re-enter information in from your estimate to your order entry. You just click a button. It's very easy. I'm going to show you how to do that here in a second. And access anywhere. Obviously it's optimized for iPads, laptops, cell phones. I mean, this was made by people that are my age or younger. I mean, it was made by people in today's world to know that this is how you do business. You don't just do business on a desktop computer. So it's very optimized for that. And I'm going to show you that. Yesterday was a very real world situation where Steve and I had a customer at our front desk saying, I need an estimate on what this would cost me to do, what my title premium is. And we talked about how premium rates have changed. Well, we have several different apps that we can use to quickly do an estimate, as I'm sure that you are as well. There's so many resources out there. All of those apps were wrong. They were not updated for the new policy amounts, which kind of alerted us to say, let's look at our own app and make sure that ours is updated. And so I did that, and I want to show you exactly what that could look like from your app on your phone. So this is what I did. I clicked get a quote, 3 different ways to do that here. I went ahead and put in the property address, and this is linked in with Google. So it's going to drop in all my city and state stuff. I don't have to do that again. Put in my loan amounts, purchase price, hit next, see where it takes me. Yeah, obviously I'm going to close the StoneWall Title. Where else would I want to close? I'm going to click next, and this is going to take me to a page where I get to select what type of policy I want, who's paying for the policy. You'll see that next year. My phone just kind of froze up, so I'm kind of stuck here for a second. And it's so customizable, it's so easy. It's just, I mean, you're fixing to see how quickly you get this.
So this is calculating your closing title policy or your closing cost?
Both.
Both.
Yeah. So you're fixing to see the quote that comes out here. It has what the buyer pays, seller pays, and then each line item as well. And you said, this is all well and good, but how do I get it to my customer, right? First, I'm going to review the order. These are all the correct details. Yep, that's all right. We're going to go back to that page. And this right here, click share. I can drop an email in there. Feel free to spam me with other, questions on my email address. And then you can write your client a particular note. Here's the estimate for this property. I hope that this works out. Let's close it soon. Send that off, and it's going to take you back to your home screen. And like I said, it's going to save every quote that you do. So right here, I'm going to click quotes, and every quote that you've sent out, you can follow up on,
Wow.
or you can click it and just click order, and that will order it with us. So no more retyping information. That's cumbersome. That is not the 21st century. You upload your contract and you push send, and it shows up on my desk. It gets put in within 5 minutes. Now let me show you what the borrower sees. We sent that email. Look at all my junk mail there. This is the email that they get. Here is the estimate on that property. Click on the PDF. It's very professional looking. It's StoneWall Title has branded it, so you know that it's coming from us. It's a trusted source, and it outlines everything on the borrower side, seller side, what this could look like. And of course, there's seller net sheets. There's different ways to do this type of estimate, but that is what it could look like. So it's very powerful. The app is very powerful, and all you need to have that is just a login. And once you're logged in, you're logged in. You don't have to do it anymore. So it's incredibly useful, incredibly powerful, something that no one really knows about. No one's really utilizing, I think, to the best of its ability. But it's so wonderful, so helpful. And that exact same estimating tool is also on our website. So if you go on our website, the very bottom right has a little house that pops up. It says get free estimate now. You click on that, it's the same screens that you go through. So easy to do desktop or remote.
So one thing that, I would encourage you guys to do too, and your peers, like Pam said, once you are familiar with this, the applications that are available, it's super easy to use. But, if you're not as familiar with that type of software, or, if you, just haven't done it before, we're always available. And if you want to just stop by our office the first time or two and say, hey Steve, or hey Pam, I want to send an estimate to somebody, or I've got the contract, but I want you to help me set it up through Qualia and let me submit it that way. Come on in. We'll sit down with you in the conference room, wherever, and we'll work with you to actually utilize the software the first few times you use it, and then that way, you'll learn to be familiar with it, and you won't need that additional assistance with us.
Right.
And we don't necessarily think you will anyway, but
Right.
we don't, we're glad to just walk you through it as many times as you need us to on the front end till you learn it.
Definitely, and I, more than doing these types of classes, my favorite type of class, and I think the most useful, is to do one-on-ones. And I'm happy to come to your office here, and we sit down with my laptop, set up your account, get all of your notifications corrected, all of your preferences in, for you to be good to go. I'm happy to do that. I've done it several times for other real estate teams. It's a big deal for their teams to all be connected in through the accounts, and then also for individual realtors to make sure they can definitely utilize it for what it's worth. I mean, it's free to you guys. It's really easy to use. And just to recap, we were the only ones that had the correct title premium. So, hey. So any questions I can answer? I know that was a brief overview of a very powerful thing, but I hope it just kind of highlighted the strengths it could provide for you and the benefits for you.
Well,
Yeah,
I thought, oh my God, another one.
I know, it's always another one.
I will say this, the more I learn how to use it, the better I like it. So a lot of it I don't know how to use, so I may show up.
Yeah,
But the more I learn how to use it, the more efficient I find it to be.
well, I appreciate that. That is the goal and that is the hope, and if it's ever anything different, I want to know about it.
Okay.
And we have a direct line with Qualia to make it better. So if you see something also that you're like, man, it would be great if we could do this, let me know. That goes straight to Qualia's ear, and they are very responsive about adjusting it to make sure that you guys are getting the best use out of it, and it's for you. So we want to hear that. Thank you so much.
My last question.
Please.
I noticed that the last names of the Are y'all related?
Guilty. Guilty. Steve is my father-in-law.
Okay.
And Samuel, my husband, is the other attorney at the Reed firm.
Okay.
Yes, so.
Well, that's
Guilty,
job
guilty.
security.
That's right, that's right. That's right, so.
And a lot of extra pressure.
Yeah.
You're gonna put up the lot.
Anything else I can answer for you
You
guys?
were the first in Texas to follow it, correct?
We were definitely a beta site for Qualia at first, and we helped them get Texas ready. So we kind of serve as a spokesperson for them, and a testament to the power of Qualia and what it can bring. And we really feel like Qualia is going in big places,
Right.
as are we. We have big plans at StoneWall, plans like remote notary type of closings where you don't ever have to come to our office anymore. That's cool. We can close it online in your PJs at your house. And we are capable and set up and ready to go on that. In fact, to be an online notary, there was only 200 people in the state of Texas, which, you know, to some people are like, wow, that's a lot. No, it's not. It's not a lot at all. We had 4 of those people in our office, certified, ready to go, about 6 months ago. So we are ready and waiting for the very next thing that's coming to your office, that's coming to your clients that they'll be expecting. We're ready to go, and that's, you know, continuous with what Qualia sees as far as they're continually innovating for our industry and keeping up with your industry as well.
Did you have to go,
Sure.
did you have to go through a background check to get qualified?
To get Qualia?
Get qualified to be a online closer, I guess.
Oh, yes.
Yeah,
So you
you-
have to be a normal notary, and then you have to go through a bunch of other things in order to be
Good.
an online notary.
Yeah, it's a, you have to have a secure online signature, and you have to actually create an online vault
Okay.
that your online signature and your online notary book reside
And your
in,
stamp.
and your stamp.
You have to have a digital stamp.
And then,
You have to have the ability to hold all of those recordings securely for a number of years.
Okay.
Yeah.
So it doesn't go to the cloud, you have to have the capability of holding the data.
well, no, you can record it in the cloud, but you have to have a secure cloud database
Okay.
for it.
Right, yeah.
So it's, it's really interesting. The authentication process that the signatories, the signers have to go through, that you have to put them through is very, very interesting.
Yeah, I would think
And
so.
it's a lot like, not a lot, but it incorporates some of the processes that you have to go through if you want to log on to your bank account or whatever. And so there's a lot of secure questions, and it's really interesting because of cyber fraud. A lot of those are kind of what I'll call Americana type questions,
Okay.
if you will, so that someone that's foreign wouldn't necessarily
Would be disadvantaged.
it would be very disadvantaged in terms of trying to answer those questions. So it's a really interesting process. We thought we were going to do a Ron just a couple of weeks ago, but the guy that was the signer on that transaction was Canadian, and you actually have to have some U.S. Credentials and
Credit type of.
yeah, you have to have a
You have to be in the U.S. system.
a U.S. credit report, because a lot of the information that they use to create the questions and to search your background are tied to that.
Yeah, it's like
Systems.
what color was your first car? Those types of questions that you're like, "What color was my first-" you know what I mean? Like they're almost a little bit challenging for a lot of people.
Well, yeah, they'll say, was your first car one of the following? And they'll
Yeah.
put in stuff that's clearly not an American car or ever have been, but
Right.
you
With the
wouldn't
back-
necessarily know that if you.
Exactly.
So it's like the FAFSA.
Yes.
I mean, they ask you
A
all.
lot of people use those same. It's pretty cool. You hold up your driver's license to your camera, and it runs through authentication. So it's much more secure than bringing us your driver's license, where we're like, yeah, that's a real driver's license. It actually runs through all of the driver's license databases and matches you with your license.
So that is one of the challenges too, if you, and I'm sure it'll get better and better, but if we were gonna do a remote closing, Pete, and you were the site buyer and you were signing documents, wherever you are, the software that you're using or the hardware that you're using to communicate with us, the TV screen, the computer, whatever that is, it has to be a certain level because, like, for example, it does take an image of the driver's license and it has to have a clear enough image
So they have
to
to have
process that.
current Adobe's and other different types of software that older systems might not have.
Yeah, or it just have to,
Just a
have to
pretty
be a
good
high
webcam.
enough resolution,
Okay.
Yeah,
You know.
pretty good webcam.
yeah, so.
So you'll get to see some of those things coming because they are coming.
They are coming.
And we're ready. We're excited.
Good. I think it's good to lead. Good to lead.
Well, we're
We're
trying to
happy to
be
do
ready.
it.
Really, the banking industry, the mortgage industry is gonna be the leader of that charge because until they're ready and they say go, it isn't gonna happen. So what we're trying to do is make sure, once they get to that point, and we're way ahead of, I think, where they are on the title side, but once they get there, then we'll already be ready.
We're ready to go.
Good.
Well, thank you guys so much.
Yeah, we really appreciate
You
your
have my
time.
contact info.
Appreciate y'all.
Thank
It's
y'all.
really-
Awesome.